Wabarakatuh. Hello everyone, we are from Group 5. We'll explain about criminal law. I am IRZAN RONAZY from the Law Undip. Will explain about the definition of criminal law. Criminal law is the whole of the rules that determine what actions are prohibited and included as a criminal act, and determine what punishment which can be dropped against those who did. And this is an example of the types of death penalties. Death penalty is widely applied in various countries, especially Indonesia. Prison criminal cage, criminal fines, and criminal cover. Thank you very much.
Okay, thank you very much, IRZAN. My name is ADDURA, and now I will explain about the source of criminal law, the principles of criminal law, and the kinds of distributions of offenses. First, I will explain about the source of criminal law. Source of criminal law can be distinguished from source of written law and source of law that are not written. In Indonesia itself, we don't have a national criminal code, so the criminal code inherited from the Dutch East Indies colonial government still applies. The systematics of the criminal code include first is Book 1 about general provisions, Articles 1 to 103, and Book 2 about crime, Articles 104 to 488, and Book 3 about violations, Articles 489 to 569. And there are also several laws that regulate special crimes made after independence, including 1 UU number 8, year 1955 on immigration crime, and the second is UU number 9 of 1967 concerning drugs, and the last is UU number 16 of 2003. Concerning anti-terrorism, then I will explain about the principles of criminal law. The first is the principle of legality. No action can be punished except the strength of the criminal rules in the applicable legislation that exists before the act was committed. Article 1, Paragraph 1 of the Criminal Code. If after the act has been committed, there is a change in the applicable law, then what is used is the rule with the smallest penalty for the accused. Article 1, Paragraph 2 of the Criminal Code. Second is the no penalty number 1 principle, or we call it geen straf zonder schuld. To punish a person who has committed a criminal act, it must be done if there is something wrong with that person. Third, the territorial principle, namely the provisions of the Indonesian consultative law regarding criminal events that occur in the areas that are in the territory of the United States of the Republic of Indonesia, including Indonesian flagged ships, Indonesian aircraft, and Indonesian embassies and buildings abroad. Article 2, Criminal Code. Fourth, the principle of active nationality, which means that the provisions of Indonesian criminal law for all Indonesian citizens who commit criminal acts wherever they are. Article 5 of the Criminal Code. And the fifth is the principle of passive citizenship, namely the provisions of Indonesian criminal law for crimes that benefit the states. Article 4 of the Criminal Code. Continue to the various distributions of offenses. In criminal law, there are 4 kinds of division of offenses, namely, first is an offense committed deliberately. For example, deliberately seizing the soul of another person. Article 338 of the Criminal Code. An offense due to carelessness, for example, because his mistake has resulted in the death of another person in the traffic on the road. Article 359 KUHP. Second is conducting theft or fraud. Articles 362 and 378 of the Criminal Code, and not carrying out things that should be done according to law. For example, not reporting a conspiracy plotting treason. And the third is crime. Book 2 of the Criminal Code is a very disgraceful act, regardless of whether or not there is a prohibition in law, because it is also known as a legal offense. And the last one is a violation, Book 3 of the Criminal Code, an act that is considered one of those preciously because of the prohibition in law, because it is also called a law offense. Maybe that's all from me. Thank you very much. By Amelia, Siti, AZZAHRA, or Ara. Thank you.
And now I'm gonna talk about the example case of penal law, which is corruption that just happened recently. The KPK continues to investigate the alleged corruption case of social assistance funds, or BANSOS, by former Social Affairs Minister Juliari Batubara. And one of them, the KPK will investigate the alleged flow of illicit money in the bribery case for the provision of COVID-19 social assistance. Shockingly, this money is allegedly enjoyed by other parties too. The anti-corruption agency also spoke again about the potential death penalty against Juliari Batubara. According to KPK Deputy Chairman Alexander Marawata, the threat of death penalty can be given to Juliari Batubara in accordance with Law Number 31 of 1999 concerning corruption eradication crime. Alex said in Article 2 of Law Number 31, year 1999, it is possible to demand the death penalty if it is proven that there is a loss of state finance from the actions committed by Minister Juliari. Okay, I think that's it from our group. Thank you for your attention. Wassalamualaikum warahmatullahi wabarakatuh.